Hello, and welcome back to the last episode of Financial Triage, where we talk about financial planning and how it impacts your finances. We are going to cover a lot of information in each episode. As everyone is in a different place financially and has different values and goals, not all of this information will apply to you. You can download the slides by using your camera app on this QR code, which we will show periodically during this broadcast. If you have questions, please note them in the chat at any time. We will answer all questions at the end. As we are going through these topics, if there is a particular segment, topic, or situation you would like to see a future seminar about, please leave it in the chat or message the organizers at academy@bedfordpresbyterian.org. My name is Jennifer Climo, and I have been providing income tax advice to individuals for 30 years and financial planning advice for 18 years. I'm a certified public accountant and a certified financial planner. The views expressed today are mine alone and are not the views of either Bedford Presbyterian Church or Milestone Financial Planning. Nothing you hear today should be considered investment advice. Do not make financial decisions based on this or any other seminar, but instead meet with a qualified financial advisor regarding your specific goals and financial circumstances. Note that almost all financial decisions will impact your income taxes or estate taxes now or in the future, and the tax consequences should be evaluated before you take action. Past performance of investments does not predict future results. TRIAGE is the acronym we came up for this series of classes. Today's topic is the E in TRIAGE, estate planning. Estate planning is the art of ensuring your assets pass where you want them to go after your death in a tax-efficient manner. At the end of today's class, I hope you will understand why you need estate planning, even if you don't have to worry about estate taxes, why you might need a trust, how to use beneficiary designations, and how to plan to efficiently transfer your assets to your heirs. Estate planning is one of the most critical areas of financial planning. One of the first things that we do with new clients is to evaluate their estate planning documents and make the appointment with the estate planning attorney right then. Notice I did not say real estate attorney, corporate attorney, or my brother's an attorney. As with any area of law, the ramifications of poorly written estate documents can cause real heartache. Please find an attorney that specializes in estate planning and elder care for this task. I have seen the following situation. This individual, Steve, we'll call him Steve, did not take our advice to use an estate planning attorney and had a general attorney draft their estate planning and deed. Steve is married to his second wife, and he had 2 sons, one of whom hadn't spoken to him in 30 years. Then Steve died. Unfortunately, because of errors on the deed and in the will, the house ended up being tied up in probate, and 2/3 of it passed to his children, including the one he had supposedly written out of his will, and his wife, that part of the money bypassed his wife. She had to move for elder care reasons. She couldn't take care of herself, and the probate delayed the house sale for a year. In addition, both children had to disclaim their inheritance in order to allow her to receive the funds so she could purchase another home. The troubled son initially refused, causing a permanent family rift. Don't let this happen to you. Use legal counsel that specializes in estate planning. A good person leaves an inheritance for their children's children, but a sinner's wealth is stored up for righteousness. Proverbs 13:22. What is probate? A lot of what I'm going to say tonight involves avoiding probate. So I'm going to take a minute and tell you what probate is. Probate is a public legal process for settling your assets after death that do not have beneficiaries listed on them. Everything has to be filed with the court in probate. The process is expensive, time-consuming, can take a year, and public. Your assets and financial information are part of the court records. It is good practice in most cases to avoid probate. Note there are certain circumstances where some assets have to pass through probate, but those involve Medicaid planning for spouses of people who may need Medicaid, which is beyond the scope of this talk. Below are some more real-life situations that proper estate planning would have solved. Imagine you don't have any estate planning documents and you are sick in the hospital or you had a stroke, unable to make decisions for yourself. Your spouse will be unable to make financial decisions for you, get into your financial accounts, or use your money to pay for your home care because there is no durable power of attorney on file. I've worked with several widows over the years who did not involve us prior to their planning, and some of those situations were absolutely avoidable paperwork nightmares. Assets were titled in just the deceased spouse's name that bypassed her, went directly to their kids. Assets were still titled in his parents' names. Assets had no beneficiaries on them and had to pass through probate. The situation literally took years to resolve, and it was all completely avoidable. It's very sad when this happens because the spouse is also dealing with the shock of the death of their loved one. Let's say you get divorced and you forget to change your beneficiary designations from your ex-spouse. You get remarried, and then you pass away. Your life insurance and 401k pass to your ex-spouse, bypassing your current spouse. Not ideal. You set up a revocable trust, but you forget to fund it. You get this big packet of legal paperwork from the attorney, and right in the drawer it goes. Nothing was titled into the trust. The trust was not named a beneficiary of any assets, all of which you have to do after you get the documents. You die, nothing's in the trust. Ouch, waste of legal dollars. And the assets now have to go through probate. Worse, there's no trustee to manage the transfer of assets. There might be an executor, but you have left them a huge mess to clean up. Another situation is second marriages. You are divorced with 2 children. You remarry, you make your new husband the beneficiary of your accounts, you pass away. The kids fall out of touch with their stepdad. He remarries and leaves everything to the new spouse. Kids get nothing. All, again, completely avoidable. In my opinion, the most critical tools for estate planning are the durable power of attorney, the healthcare proxy, and beneficiary designations. The durable power of attorney, DPOA, is in charge of your money. Who is in charge of your money while you are alive? Your healthcare proxy is the person who's in charge of your medical decisions when you are incapacitated. Beneficiary designations. I love these because they are so easy to update. They don't require paying any legal fees. And you can factor in generosity by leaving a portion to charity and or to your heirs. These are less powerful these days because only spouses can take the tax stretch and stretch retirement distributions over their life expectancy. Most others have to spread it out over 10 years after they turn age 21, with some exceptions. Now, when you inherit an IRA or 401k or other retirement account now. But beneficiary designations are very powerful. They are free, easy to administer, no legal costs, and bypass your will or trust. Important note. Simply get a form from your financial institution and decide how much of that asset you want to pass to whom. Each form controls one asset, so they're asset by asset. Life insurance policies, each policy will have a separate form. 401k, IRA, Roth IRA, annuities, brokerage investment accounts. All of these you can name beneficiaries on. HSAs, pretty much anything that's a financial account you can name a beneficiary on. Note that if you do not use a beneficiary designation on your retirement accounts, they will have to pass through probate, and they will have to be emptied and taxed over no longer than 5 years. If you name a non-spouse beneficiary on your retirement accounts, they will potentially have to empty and be taxed on the retirement accounts over 10 years. But by naming the beneficiary, you get an extra 5 years of taxation for tax to whoever inherits them. Therefore, name beneficiaries, but be careful who you name on which accounts. We suggest naming charities, if you're charitably inclined, as beneficiaries of IRAs, so no one pays the taxes. Roth IRAs are great to leave to your kids, as they are tax-free. Taxable trust accounts, that's brokerage accounts, can be used for any beneficiary tax-wise. Many people may not realize that you can name a beneficiary on your bank accounts and, again, your HSA. Most people are aware that you can name one on your IRA or 401k. Unfortunately, some beneficiaries believe once they inherit that they need to take the entire account balance out of the account the year they inherit it. Depending on the type of account you inherit, this may result in unnecessary taxes. If you call a financial institution and you tell them a customer passed away and you are the beneficiary of their IRA or 401k, in many cases, they will transfer the money directly to you. They'll send you a check, resulting in an immediate tax hit. Since all the money is taxed in a single year, it may push you into a higher tax bracket, making you pay a lot of additional taxes. If you do inherit one of these accounts, ask the question, can I open an inherited IRA? That will allow you to spread the money over 10 years if you're not a spouse and save a bunch in taxes. If you name an individual or charity as a named beneficiary, all of these taxes can be avoided. If you have more than one beneficiary, for example, 30% to charity, 70% to an adult child, you can split your beneficiary designations any way you want. If one of your beneficiaries is your adult child, after your death, they can open an inherited IRA at a financial institution, transfer the funds there. They can then spread the taxation over 10 years, as I keep mentioning, often greatly reducing the amount of taxes paid. Note regarding HSAs, they grow tax-free for medical costs while you're alive. Your spouse can inherit this tax-free, but nobody else. If someone else inherits it, it's taxable at that time to that person. As we just discussed, naming a beneficiary on your IRA, 401k, and other to-be-taxed retirement accounts can save your heirs taxes. Your will is of last resort, in case you forgot to put something in trust or add a beneficiary. Wills must pass through probate, which is expensive, public, and time-consuming. A great strategy for charitable giving, as discussed last week in generosity, is to use your IRA to fund your charitable giving. In addition to the QCD that we discussed last week, you can simply use the beneficiary designation form to leave all or a portion of your account to charity. You can also move a portion of the account into a new IRA with a separate beneficiary. What about crypto? I have not yet seen a way to avoid probate with crypto. I haven't seen the ability to put any beneficiaries on any crypto accounts. If you are aware of a custodian that allows this, please message me or send us a note in some fashion. That would be interesting. Now we're going to talk about what is a step-up in basis. You may have heard this terminology a lot, especially as the government talks about maybe squashing and getting rid of the step-up in basis. When you purchase an asset, that is generally the value that is used for your cost basis when you sell to determine your capital gain. Any gain or loss is the difference between the selling price and your cost basis. Basis can be adjusted by other things, but that's beyond the scope of this talk for right now. I'm going to keep it simple. At your death, the value of your assets may be taxed. So your basis of all your assets is marked up to the date of death values, known as the step-up in basis, so that you don't pay capital gains tax and estate tax on the exact same amount of growth. This is the reasoning behind the step-up in basis and why there is such a thing. A planning strategy that comes from this is that if you know one spouse is going to pass away first, due to, unfortunately, a terminal disease, but not sooner than 1 year, you can move low basis assets into an account in the ill spouse's name and name the surviving spouse the beneficiary. After death, the assets receive a step-up and avoid capital gains taxes. Note that you can't do this really close to death. It needs to be a year in between. And this is not really something that you're thinking about if your spouse is going to pass away within the year, and you know most people are not thinking about taxes. But your advisor, this is a situation where your advisor could help save some significant taxes. Trusts. Trusts are legal entities created by an attorney that spells out the terms of the trust in writing. It's a written document. There are two main kinds, revocable trusts and irrevocable trusts. There are lots of subkinds within these buckets. A revocable trust only protects your assets from probate. It does not protect you from any liability concerns. It's just probate protection, streamlines the distribution of your assets in accordance with your wishes. The only way to protect your assets against liability claims, as we discussed during asset protection, is to give up control of your assets. You can change the terms in a revocable trust anytime while you're alive, hence the word revocable. Once you pass away, the trust becomes irrevocable. This is very confusing if you use the word revocable in the name of your revocable trust, because the so-and-so revocable trust will become irrevocable at your death, but the name doesn't change. Assets titled in a revocable trust avoid probate. They can also avoid estate taxes on the second death if the trust is set up correctly. Some taxes. Common pitfall with trusts is that you create one and then neglect to title everything into the trust. As we mentioned earlier, you need to actually, the lawyer will usually put the deed of your house or any real estate into the trust, but you need to title your other accounts, your bank accounts, your investment accounts, et cetera, into the trust and possibly name the trust as a beneficiary on your other accounts. Once those accounts are in trusts, they have built-in beneficiaries as written into the trust document, and they don't need additional beneficiary designations. Note that qualified accounts such as IRAs, Roth IRAs, and 401ks, 403bs, TSPs cannot be owned by a trust. They must be owned individually. You will use beneficiary designations for these assets. You can leave them to a trust if you want to, but you can't transfer them into a trust. If you have a disabled child, a revocable trust will often include a special needs trust inside it. Once you pass away, the revocable trust becomes irrevocable, and any money that is set aside for your disabled child is protected by the special needs trust without disqualifying them from public benefits if the trust is written correctly. Another important to do if you put your house in trust is to make sure you let your homeowner's insurance company know so they add the trust as an additional named insured. In many states, the only way to put a beneficiary on real estate is to own it in a trust or LLC. In New Hampshire and Massachusetts, you can put the house into your revocable trust. You want to be careful about in evaluating whether you have a single trust that owns the house or a joint trust that owns the house, as when the first person dies, if they own the house in a revocable trust or outright, there's a step up in basis. After the first to die, whatever's titled in the trust no longer qualifies for the capital gains exclusion that you have on your residence, because a trust is not a person, a trust can't live anywhere. Once it's owned by the trust, if there's a lot of years that go by, there can be some appreciation in that asset, that piece of real estate, that could then be taxed in the future. Something to consider when you're looking at what kind of trust, should the trust own your house. Make sure you title your assets into your revocable trust, but not your qualified accounts. It's the lesson there. Should I have a revocable trust? If you have assets or equity in real estate or a small business worth more than, let's say, $500,000, or if you have assets and minor children, you should establish a revocable trust, or consider it anyway. You can create a trust in your will, known as a testamentary trust, but your assets will need to pass through probate before this is funded, because as we learned about wills, if anything going through the wills has to go through probate. One common use case for a revocable trust is if you have children but are no longer married to the other parent. If you get remarried, you often want to protect your new spouse for their life, but then you also want to make sure that any leftover assets pass to your kids and grandkids so that your kids don't lose access to your money. I work with many people in this situation. It's very common. The revocable trust can be changed during your life. It can provide for your spouse during their life, because remember, when you die, the trust becomes irrevocable, which means it cannot be changed. It provides for your spouse while they're alive, and then after they pass, whatever's remaining passes to your children or wherever you want it to go. You do need to name, with any trust, you need to name a third party as a trustee to handle and distribute all of the assets. In accordance, they can work with any advisors that you have, but you do need to find that person. Finding that person that is reasonably good with organization and finances can be tricky. Oftentimes, your estate planning attorney will agree to be that person as an option. Irrevocable trusts. The trust terms and beneficiaries cannot be changed. Sometimes lawyers can add some flexible language to adjust trust terms to comply with new laws, but the beneficiary distributions are usually unchangeable. Irrevocable trusts often protect the assets from the beneficiary's creditors and from divorce or bankruptcy. You cannot protect your assets in your revocable trust, but you can protect your assets from your beneficiary's creditors after you pass away. That's one of the advantages to trusts, and why you might want to keep the trust going until your kids are 40, 50 years old, et cetera, because that's the only way you get the protection, is if it's in the trust. If it pays out at age 22, then money is out into the kids' names and subject to divorce, bankruptcy, creditors, bad business decisions, et cetera. Examples of irrevocable trusts are those created upon death, such as marital trusts or trusts benefiting children for a number of years, and all revocable trusts become irrevocable at the death of the grantor. Special needs trusts, often created in number 1 in these revocable trusts for the benefit of a beneficiary whose public benefits might be affected if they owned any assets outright, so any assets need to be left in a special kind of a trust. Irrevocable life insurance trusts, designed to own life insurance and keep the proceeds out of your estate. Medicaid avoidance trusts, designed to impoverish the beneficiary so the assets can pass to heirs instead of paying for your care. Legacy trusts, also known as dynasty trusts, designed to use a portion of your lifetime exemption, your lifetime estate planning exemption, if you may recall. It's $11.7 million. Currently, using a portion of that lifetime exemption to transfer assets to a trust that benefits your heirs over their lifetime. The growth of the assets would be outside of your estate once you've transferred the money to this trust. Those are all examples of irrevocable trusts. There is a big downside to irrevocable trusts in that any income left in them is taxed at very compressed tax rates. In many trusts, the strategy is for the trustee to pay out the income to the beneficiaries during the year, so the income is taxed to them and not the trust. Irrevocable trusts that don't pay out this income, such as dynasty or legacy trusts, where the goal is to grow the trust balance for some future date, this can cost the trust a lot in taxes. As you can see from this slide, the threshold for income taxed at high rates is very low. You're in the top bracket, over $13,000 of income. Wills are important to catch anything where you forgot to assign a beneficiary. Remember that items titled in your trust have beneficiaries as spelled out in the trust document. If you have done perfect estate planning, nothing will pass through the will. The will must go through probate if it has any assets in it, and then that is, again, public, expensive, and slow. Also, you must have the original signed paper document, paper will, in order to probate it. If you have minor children, your will is where you designate who their guardian will be if you predecease them, and that part will have to go through the courts. That is an important function of the will, actually, is if you have minor children when you pass away. What about Medicaid avoidance trusts? We've talked a little bit about this before, so I'm going to reiterate this. Medicaid avoidance trusts were designed to take a portion of a couple's assets and put them in trust for their life and then pass to their heirs after their death. In order for this to work, you have to give up control over these assets more than 5 years before you need care. Over the years, the states have fought these kinds of trusts and tried to recapture the assets to reimburse for Medicaid costs. In practice, if you need to rely on Medicaid for long-term care costs, you won't have a choice where you live, and you will likely share a room. If you first live in an independent living facility, you may need to move once you need more in-depth care. In my experience, it is better for the individual or couple to keep their assets and use them for their own care. For example, if you want to get into a CCRC, a continuing care retirement community, they generally don't accept Medicaid, and they require you to have assets to be pre-qualified and allowed in. If you've tied up all your assets in a Medicaid avoidance trust, you might be busting the trust to get your assets out to live where you want to live. Medicaid avoidance trusts are great for your heirs and not so great for you. In my experience, most trusts are broken after mom and dad run out of money to continue to pay for their care. Are you really going to move mom and dad when they're in their 90s to an inferior location? Moving anyone in their 90s is a painful and difficult process. I have never seen a Medicaid avoidance trust kept in place once the individual runs out of their own money. The kids usually bust it to pay for mom and dad's care. Therefore, you might as well just keep the money and avoid the expense. Important note, if there is a chance you will run out of assets before your end of life, and that you will need to qualify for Medicaid, you will need Medicaid, make sure you don't make any gifts in the 5 years before you are eligible for Medicaid, or else the state may claw them back to pay for your care. Practically speaking, there are other ways to avoid Medicaid on some assets without using a trust or paying a lot in legal fees. They do involve a level of risk, however. One example, one possible strategy is to roughly, if you have a couple that is late 70s, let's say, maybe starting to develop some health problems, you roughly equalize the assets between them. If one of them owns a huge IRA, then the other person owns their brokerage account and maybe the house. in their trusts, of course. Then you name the adult children, if there are adult children in this case, you name the adult children as beneficiaries on all the accounts. The children understand this is still to be used for their parents' care. All the money is still managed under the advisor's umbrella for the benefit of the parent, but any money inherited legally will belong to the children. Any taxes are paid from the funds to reimburse for the kids for the taxes paid, because they'll be getting the 1099s. However, the money isn't transferred to the kids until after the second to die, meaning they don't take it free and clear. The issue here is the money legally belongs to the kids and they can spend it. It's subject to divorce, lawsuits, et cetera. In my limited experience using this strategy, even the children who do not agree have managed to leave the money alone, likely because it is all managed by a third party and everyone signed up front that all parties receive the quarterly statements with all activities. The advantage to this strategy is the money no longer belongs to you and therefore it bypasses the 5-year Medicaid look-back. However, once again, I haven't seen anybody wanting to move their parent out of where they're living to a facility that takes Medicaid. So again, it kind of is moot to protect your money from Medicaid if you're not going to use Medicaid at the end of the rainbow. It's hard to know that in advance, but there's a lot of expense and aggravation that goes on trying to avoid this. And I just haven't seen it come to fruition in practice. Lawyers hate this strategy for obvious reasons, and it certainly does involve a level of risk. When I've used it, we are careful to equalize the assets between the spouses or only fund this with specific assets, so only some assets are transferring in this fashion. This reduces risk and also makes it less likely that Medicaid would complain about this. This is also the only way to transfer qualified accounts like IRAs or Roth IRAs without a tax liability. If the second spouse requires Medicaid within 5 years of death, Medicaid could require the spouse could say the spouse is ineligible for a period of time due to not claiming their spousal share. That's why it's important that you equalize the assets. This is again why you would limit the amount transferring under this strategy. The more time that between the death of one party of the couple and the second party of the couple, the more likely that this strategy results in passing assets to the next generation successfully and in a tax-efficient manner. If you live in a state with a low tax exemption like estate tax exemption like Massachusetts, you want to make sure you don't leave more than that amount of that exemption to a non-spouse, or you may accidentally trigger estate taxes. Why? Any money that passes to spouses at death is usually included from any estate tax. However, if you live in Massachusetts when you die and your assets that are to pass to your non-spouse beneficiaries have grown to more than $1 million in value, then they must pay a Massachusetts estate tax on the entire amount back to $1. Not ideal. Look often, keep the estate passing to non-spouses below $1 million if you live in Massachusetts if possible. This is easy to do when you first set it up, but you must also continue to monitor the asset values as they grow to make sure they don't bump up over the $1 million, especially now with the markets going crazy north. Now let's talk about estate and gift taxes. Gift taxes. You are allowed to give up to $15,000 per person per year with no extra reporting, as long as you give a present interest, which is a gift with no strings attached. Anything above that is considered above that is considered a lifetime gift and will be added back to your estate at death. If your total estate including these gifts is less than the estate tax exemption, there are no taxes due. Otherwise, they factor into your estate tax. If you make gifts above the annual limits each year, you should file a gift tax return to apply the lifetime exemption to the gift and to start the statute of limitations. Once you have filed a gift tax return, any tax return, the IRS usually only has 3 years to audit or question it unless there was fraud involved. Estate taxes apply to the net value of your investments at death, including the value of businesses you own, joint bank accounts, cars, furniture, life insurance proceeds on your life, lifetime gifts made in excess of the annual limits, currently $15,000 per year per person, everything. You get to subtract funeral costs, debt, income taxes, and charitable bequests, whether made through your will, trust, or beneficiary designations. The net amount, if over the federal limits, currently $11.7 million per person, but slated to reduce to $6 million if the American Families plan becomes law. So this net amount is multiplied by the current estate tax rate, which is a sliding scale between 18% and 39% for a taxable estate between $10,000 and $1 million. And the tax rate goes to 40% on the total assets above $1 million. Note that a taxable estate of $1 million means that your net estate was $12.7 million, because you get an $11.7 million exemption plus the million, $12.7 million. But again, Congress is talking about adjusting that limit, and Congress is always talking about adjusting that limit up or down. So it is something to watch, because if it drops down into your net worth level, it could affect you. And certainly there are still many states, such as Massachusetts, that have very low estate tax limits that could make this apply to you. Reminder that all your income is subject to income tax during your life. If you save and invest that income, the entire amount of the savings is then subject to estate taxes at death, but currently only for the very high net worth, as we just talked about, unless you live in low exemption states such as Massachusetts. As we keep talking about, Massachusetts only has a $1 million exemption, and if you die with more than $1 million in your name, including life insurance proceeds, your heirs may be subject to estate taxes on your entire estate back to $1. There is a marital deduction if it passes back to a spouse. You don't have to pay any taxes until after the spouse passes away. We often use revocable trusts to protect the first $1 million at the first spouse's death from estate taxes. It's a good use of revocable trust. When evaluating estate tax avoidance, make sure you review all tax liabilities to see what makes sense. I had a situation once where it made more sense to move an account out of the joint account to one spouse's name, who unfortunately had a terminal disease, because it received a step-up in basis at death. It was a very, very low basis asset. The income tax effect was much larger than any potential Massachusetts estate tax savings. It's an interesting case. Summary of estate tax avoidance. When doing financial planning, we will tell a client to watch their spending lest they run out of money in their lifetime. Save, save, save. You'll remember that from the earlier episodes. Estate tax planning is if the opposite happens. It's at the other end of your life, the markets cooperate, the stars align, and you end up dying with assets in excess of the estate tax limits. As this can result in a lot of money passing to the government instead of to your heirs or charities, traditional planning works to avoid the estate tax. To summarize the options for planning, they include lifetime giving strategies, such as giving $15,000 per year per person, plus you can make unlimited gifts if you pay medical costs or education directly to the facility. You can pay unlimited amounts for people's medical care or education. No gift tax involved. Lifetime giving to charities via donor-advised funds, CRATs, CRUTs, CLTs, or directly. We discussed all of that last week. Using irrevocable trusts to protect life insurance proceeds from estate taxes. Partial Roth conversions reduces your estate by the amount of income taxes you pay. There's a lot of other more complicated strategies, but these are some of the basics. Prenups. What's a prenuptial agreement? I've seen an unfortunate situation where a parent died with a revocable trust that paid out directly to his children. It was a probate avoidance trust only, so it didn't remain, the assets didn't remain in the trust, they just paid out to the adult children. His son put the money in his own revocable trust that he had with his wife. 20 years later, they got divorced, and he had to split that inheritance with his wife. Had the inheritance stayed in the original trust from his father, it would have been protected. However, in many divorce cases, the judge will look at the remaining assets and can assign a larger percentage of them to the spouse because the other spouse has other assets in trust or otherwise. I have seen this happen. This can all be prevented by using a prenup before you get married. In the prenup, any assets accumulated before the marriage are not subject to split in the divorce proceeding. Prenups have certain requirements in order to be valid, such as both parties having legal representation and a certain number of days passing between the signing and the wedding. Divorce. If you do get divorced, one of the first things you should do is update your estate planning documents. If your spouse cheated on you, you may not want them in charge of your money or healthcare decisions. Also, you want to always update your beneficiaries, as we talked about before. Small business owners. Small business owners should also be thinking about business estate planning. What will happen to your business, your employees, and your customers if something happens to you? If you were a sole proprietor with a successful, thriving business with employees, you really need to be thinking about how to add another owner to your practice or a predetermined sale if something were to happen to you. These are known as buy-sell agreements, and they are often funded with life insurance. This could be a use case for permanent life insurance, although I really don't like paying 10 times as much for life insurance, so I generally like to use term for this as well, depending on the time horizon. The important thing is that you think about these topics. Stop thinking about death and disability from an emotional perspective, from an emotional point of view, and think about the logistical problems, because not preparing for your death or disability can make life so much harder on your loved ones than the death or disability itself. There are some relatively easy ways to protect your loved ones by protecting your assets in the event of death or disability. Some involve spending a few $1,000s on estate planning, but others are as easy as filling out a beneficiary designation on your financial accounts. However, you should understand the tax ramifications of every decision. This now concludes our triage series. To summarize, determine your values, write down your goals, document where you are starting from with your net worth statement, identify your saving strategies, live within your means, reduce your bad debt, identify your risk tolerance, establish an emergency fund, continually save and invest, review the tax impact of any decision, be generous with your money in addition to your time. Taxes, understand your tax bracket and ways you can save on lifetime taxes, not just in a single year. Use tax diversification, evaluate the tax impact of every decision. Retirement, understand what a safe withdrawal rate is. Know when to collect Social Security, when to apply for Medicare, and what are the different plan options and what do they mean. Investments, understand them and what they cost. They are the engine that powers your financial plan. Invest like the rich, own stocks. Don't let fear drive your investment decision. Own a world-diversified portfolio with hundreds, if not thousands, of different companies and stay the course. Review your asset protection, umbrella insurance, health insurance, long-term care insurance, life insurance, disability insurance. Make sure your investment asset allocation matches your risk tolerance. Incorporate generosity and giving strategies into your plan. Review your estate planning. Who has control over you, your health, your money, if you are incapacitated or dead? Look beyond your spouse. This concludes our financial triage series. I hope you learned some things or found a few useful nuggets of information that you can bring to your financial advisor for more details. If you don't have a financial advisor, I strongly suggest you find one. Thank you for watching. Are there any questions?
I have a question.
Yes.
So does everyone who is not a spouse need to withdraw money out of a retirement account after 10 years?
There are exceptions to that. That's beyond the scope of this talk, but there are exceptions to that 10-year rule.
They can send in questions.
Yes, they can put questions into the chat if there are any questions. Yes, go, Mary Beth.
So you said your retirement accounts can't, oh, sorry. You said your retirement accounts can't be in the trust, but you can
Correct.
designate the trust as the beneficiary?
Correct.
But if you do that, do they go into the trust and then are just combined with all the other assets and distributed, or can they be specifically identified, like you said, if you want
Right.
your 401k to go to your children or something like that?
So if you want them to go a specific place, you just give them a beneficiary designation form. If you want them to stay in the trust and be protected, then that was why you would use a trust as a beneficiary, or if, let's just say, whoever's inheriting it isn't good with money, and they wouldn't be good inheriting a large sum of money outright. or might not know the tax ramifications of pulling it all out. You can put it in the trust. Trusts are, if it's a well-written trust, the trust pulls out the qualified retirement plan money separately and specifically covers all the tax attributes of that. Under the new secure law tax change in 2017, applicable to 2018, it passed. It all changed how trusts work. And so there's some debate in the industry as to how retirement accounts in trusts are going to be taxed and whether the spouse will still get the stretch if it's in trust. So that's a huge question. So what we do is we try to always name the spouse outright first. But I have, again, in a divorce situation where you want to provide for your spouse while they're living, but you want the ending money to go to your kids, you almost have to use a trust and take that risk that the spouse isn't going to get that tax stretch, that 10-year tax stretch. That's a bit of a question right now. So depending on where you are on that, you can say, oh, the spouse will still get the tax stretch because that was the intent of the law.
Yeah.
But it's not black and white, clear cut.
So another question, if you said the revocable trust becomes irrevocable upon death, is that
Correct.
the death of the first spouse or the second spouse?
It depends. So there's situations where you'll have, let's say John and Jane are married, and they each have their own revocable trust. So then it's very clear. John dies, his becomes irrevocable, but hers is not. Now you have a joint trust, which is, let's say, the Jones family trust. It's irrevocable upon the second death.
Okay.
But very good questions.
Can you talk a little bit more about the using life insurance for the buy-sell agreement with business or
Sure.
estate planning?
Sure. So it depends on the business, but let's say you have a situation where you have two partners that own a business, and let's say the deal is if one of them dies, the other one's going to buy them out. So what you would do is they would each possibly own life insurance on the other person. Or the business could own the life insurance. It's another way to do it on the person. And then any proceeds would come in tax-free to the business, which they could then be used to buy the stock, buy out the ownership. So you always want to have enough life insurance to cover that potential cost, which is hard because that means everybody has to be insurable, which isn't always the case. Or a lot of years have gone by, and now there's not enough insurance, but you can't get more. And also with term insurance, at the end of the term, it ends. Boom, you're done. But sometimes you can say, well, I'm planning on leaving in 10 years, so I'll get a 15-year term policy, way cheaper than permanent life insurance. So you save so much money, and you've got that overlap in case you're like, oh, I stayed on another 3 years or whatever. So that's how you can, I don't know if that answered your question.
So I have a question about special needs trusts, and
Yes.
how often should a special needs trust be updated?
Ooh, that's an excellent question. Well, again, all trusts should be updated or at least reviewed by your estate planning attorney since the major law change the Secure Act passed. I think it's late 2017, early 2018. But because the wording changed, so many things changed, and the definition of I don't want to say it wrong, but some very specific things with trusts have changed, and so they absolutely need to review that
Okay.
to make sure that it's not going to have an adverse effect.
Okay, that's good to know.
It's always good to review your estate planning at least every 8 to 10 years anyway with your estate planning attorney. Usually laws have changed, and often your situation has changed, your financial planning is different, your kids are older, and now you can add your kids to all your healthcare forms, so because they're now young adults, so now they can be able to call the hospital if you're ill, for example. That's a HIPAA form. You want them on that. By the way, I do, especially when people are doing estate planning every 10 years, if the kids are 15, I will add them to the HIPAA forms because we're not looking at this for another 5 to 10 years. And honestly, if something happens when they're 16, so they can call the doctor, great. It's not making a decision, it's being able to call the doctor, which is a really important thing. You want to make sure that anyone who's important to you is on that list.
Yeah,
But-
another question along special needs trust, because I actually didn't know about what a special needs trust was until I randomly attended a workshop at the Moore Center in Manchester. And when I was there, everyone else around the table was at close to double my age. And I felt horrible that all these people were just now learning about a special needs trust when they'd been raising a child with special needs for
Right.
decades.
Well, fortunately, a lot more people know about special needs trust now because of the internet. So, but yeah, I mean, a lot of people don't think of estate planning until they're older, which is unfortunate because I also had, it's another situation I had many years ago. It was horrible. It was a couple in their late 30s, early 40s. They were getting divorced, no children, and they each had taxable accounts, and normally you're supposed to put beneficiaries on these taxable accounts, but got busy, never had time, they never got the paperwork back, whatever, and then he committed suicide. It was horrible. And so, I mean, things happen. So everybody should get estate planning, even at a young age. And if you've got kids and they're 18 plus, you can no longer call the doctor for them. So have them sign a healthcare proxy, because most likely at 18, they don't know what they're doing. They will be happy to put you in charge of their healthcare decisions, but somebody needs to be in charge. I mean, at least a healthcare proxy and durable power of attorney so decisions can be made, because when there's trauma in your life, you really don't want logistical trauma or paperwork trauma. And these things are so easy to put into place, that those documents are. I mean, a trust you can get complicated, overly complicated with trust, but and a lot of people who don't have trust really should have trust. It makes the administration so much easier on the family. So little money now for lots of savings and aggravation down the road.
I have one.
Okay.
Are the capital gains tax rates greater for a revocable trust versus personally owned assets?
Excellent question. It's actually the same, but what makes it look greater is the compressed tax rates. So you can get into extra taxes. The extra 3.8% Medicare tax, for example, will apply at a much lower tax rate than with an individual. So it's always better, again, from a tax perspective, it's better to pay out the income of trust to the beneficiaries during the year. The trust then gets a deduction for any income that was paid out, and therefore you can structure it so it doesn't pay any taxes, and all the income passes to the beneficiaries, and they pay the taxes on the assets. Often the beneficiaries are in a lower tax bracket than the highest bracket, so that works out. If they're in the highest, it doesn't matter. Okay. Thank you very much.